Hi, I'm James Clark, a lawyer specialising in data protection and digital regulation at Spencer West. In this series, I give you the need-to-know information about a new or upcoming digital law in 5 minutes or less. For each law, we answer 5 questions. 1. Who does the law apply to? 2. What does the law require you to do? 3. When is it in force? 4. Where does it apply? And 5. Why is it important? In this episode, we're tackling a big one, the AI Act. So let's get started. Who? The Act regulates the development and use of AI systems, as well as certain AI models. The definition of AI system is broad, but importantly, it does exclude basic data processing systems, including some linear rule-based systems. And so therefore, it's important to look at the definition carefully. Most of the obligations apply to the provider of an AI system, that is, the person who builds the system or has it built for them. Some, but fewer obligations also apply to the deployer or user of an AI system. The Act is risk-based, and the vast majority of obligations only apply to certain high-risk AI systems. Finally, there are also certain obligations that apply to providers of general-purpose AI models. These are models that can perform a wide range of tasks and be integrated into downstream applications. For example, large language models like those that underpin some of the most well-known commercial AI tools. Also, if you make significant modifications to a general-purpose AI model, you might end up becoming regulated as a provider of the resulting modified model. What? The Act is a product safety law. It requires the provider of a high-risk AI system to take certain steps to ensure the system is safe before it can be lawfully sold or put on the market in the EU. Those steps that a provider has to take include ensuring the use of high-quality training data, implementing a continuous risk management system, maintaining detailed technical documentation about the system and creating instructions for the user, conducting testing prior to deployment, conducting a conformity assessment to demonstrate compliance with the requirements, carrying out post-market monitoring of the system and dealing with reports of malfunctions and safety issues, and registering the system in a database. High-risk AI systems include those used to perform some common tasks, such as recruitment, the monitoring of employees, credit, health and life insurance decisions, and the operation of critical infrastructure. This category also includes AI systems that are covered by certain product regulatory regimes, such as AI systems integrated into cars, medical devices, and toys. Deployers of high-risk AI systems must ensure that those systems are used in accordance with the provider's instructions, including by exercising appropriate human oversight. They must also report any safety issues that arise with the system. There are also obligations for non-high-risk AI systems that interact with natural persons or generate artificial text or images. Certain uses of AI are prohibited outright. When? There's a staggered timeline. As of February 2025, ultra-high-risk prohibited AI practices have been banned in the EU, and companies have also been required to provide AI literacy training to staff. The provisions on GP AI models come into effect in August 2025. And then most of the remaining provisions, including on high-risk AI systems under Article 6.2, come into effect in August 2026. Finally, the remaining high-risk AI systems under Article 6.1 are regulated from August 2027. The Act applies to any companies who are putting AI systems onto the market in the EU, regardless of whether those companies are themselves established in the EU. It also applies to all companies in the EU that are deploying AI systems, as well as companies outside of the EU that are deploying AI systems in a context where the output of those systems is then used in the EU. So in other words, there is clear extraterritorial effect, and non-EU companies will be caught in a number of circumstances. Why is this important? The AI Act is the world's first comprehensive horizontal law regulating probably the most talked about technology in the world today. It's really important to remember that the Act is risk-based, and most AI will remain unregulated or only lightly regulated, especially for companies who are only using AI systems and not developing them themselves. However, some of the high-risk use cases will have broad application and touch a large number of businesses. Also, providers of AI systems won't necessarily just be big tech companies. Many ordinary companies may be using existing AI models to develop their own AI systems in-house and therefore may become providers. And that's it. Thank you.